I'm Amba, and thank you, Barry, for the introduction. I'm joined by a very all-star panel today to talk through the state of play with AI regulation. Suresh Venkatasubramanian, who is the director for the Center for Tech Responsibility and a computer science professor at Brown University. Cristina Caffarra, who is wearer of many hats, an economist with 25 years of experience and more kind of just working on many of the flagship competition cases of our time. And last but not the least, Andreas Schwab, who is a member of the European Parliament from the European People's Party. So thank you for being with us for this panel today. Just for the audience, for those that weren't here for the morning panels, the way in which we're doing questions is that Audrey, who's raising that sheet of paper right now, is going to be sort of walking around. And if you have questions, you can just flag her down, hand her, she'll give you a piece of paper, you hand her the questions, we'll consolidate them and try to make time for most, if not all questions towards the end of the panel. So the current state of play with AI regulation, we're at a moment which is sort of bizarre, where there's the seemingly straightforward task of just talking about what existing regulation, what we have, or sort of bringing up or drawing attention to enforceable regulation or imminent regulation, has somehow become this formidable challenge in an environment where we have tremendous lobbying that is sort of diverting attention from the current to the horizon, right? So we're never looking at the right now, we're looking at what's next. And so, whether that's this, industrial policy push to focus on the expansion of AI sort of in this linear fashion, or the kind of existential risk obsessed kind of debate that we saw for the last several months, that was also looking at forms of these technologies that are not even yet on market, right? We're seeing that this kind of push towards giving actors with a stake in the present a clean chit. And that's worrying for many reasons, which is why I think today we're really going to focus on what tools do we have today and how can we kind of enforce them. So I'm going to start with a question for each of you, and I'm going to start with you, Andreas, which is, what do you think is the sort of the most potent or powerful regulatory tool we have to regulate AI, and why?
Amba, that's great. Thanks for bringing me in. Unfortunately, as announced, I'm not perfectly in shape, but I'm very happy to participate aside with Cristina and others. So a warm wish of welcome from Brussels. And I'm very grateful because I was already drafting an article on this, as AI is very topical at the moment. And the whole economic logics of AI is something which we should not put in another basket compared to what we did already on platforms. When we were in Japan with our committee colleagues, and the digital minister of Japan has made a very short, but maybe a bit general, but a very short definition. AI is nothing else than a platform, only that there is a specific big set of data behind, because it's a tool, a computer and an algorithm. But in that case with AI, it has a very strong data set behind, which is shaping the outcome. And for that reason, I think it's obvious that we have to make sure that the Digital Markets Act and all competition policy related reflections can really control and mirror as much as the classical Web 2.0 applications, as much as also artificial intelligence. And therefore, I have been trying to outline a bit in the existing law that we have been voting last year, the Digital Markets Act, which was, I think, one of the most important pieces for authorities to control without censorship, without interference into their business policy, just making sure that competition is fair and reliable, maintained in between platforms and companies, that we apply this tool also to AI. And there are three elements that I would like to explain. First of all, access to data is as much as important for platforms as for AI, because all the data that AI platforms, that AI data sets are brought in, are data that very often are common ground, and therefore making sure that the access to this data is made sure is something that we have regulated very clearly and largely in the Digital Markets Act. I could go through the different articles which may Amba, go a bit too far here, so I will not do it. But it's a very clear set of rules for the access of data, which is important for competition in platforms, but also in AI. Secondly, as AI to a large extent could be considered as a search, just that you don't scroll the web, but that you crawl your own data set, fair ranking settings are another principle that has also to be respected with AI. It's true that there is that missing link to the outside of the data set, but the data set itself has to be fair and has to make sure that the rankings within it are correct. And also here, the Digital Markets Act gives very clear lines to competition authorities how to apply. And finally, and this is the third point, the transparency requirements for advertising are also laid down very clearly and can help competition authorities to apply the same rules in platform legislation as in AI legislation based on the Digital Markets Act, which makes sure that what we want to achieve in transparency requirement is something that is also important for artificial intelligence. And therefore, I believe, and I would like to conclude, Amba, with this, if we apply Digital Markets Act in Europe, if we apply competition policy in digital times as we have been doing in Europe and as the US is about to do, then we can also cover AI in the same manner. And there is exactly the same need to be for AI to be covered as for platforms. And therefore, it's very helpful that this conference is focusing on this. And I hope that you can also make a contribution for the United States authorities to work hard on this. Thank you very much.
Thank you, Andreas. I think that was also a good reminder at the start that competition regulation is AI regulation and is often a good place to start. And thank you also for flagging access to data, fair ranking, and advertising transparency as part of the toolkit. Maybe I'll move to you, Suresh. So the question again is like, what do you think is the most potent or powerful regulatory tool we have today to address AI?
We have some tools now, at least as of 2 weeks ago, or at least the beginnings of tools. We have an executive order on AI, and we have associated guidance that will be put out to agencies to do something with their own use of AI, as well as the extent to which they have regulatory control over that as well. And the exhortations to the FTC and other agencies to do that. That actually speaks to, I think, a component that isn't covered purely by competition arguments. Although, I mean, all these arguments make a lot of sense. Access to data, transparency requirements make a lot of sense, and we should have them. But a lot of the concerns that sort of weigh on me when I look at, how we think about AI deployed are concerns about bias, about equity, about, the impact on people who are subject to AI in various forms, as Alvaro talked about earlier. There's a number of different ways in which virtually every aspect of our life is controlled by it. And we need tools to protect against that. And that's where I think we have to add to the competition discussions that we're having. And so what the EO does when it talks about, transparency requirements, it talks about testing requirements, right? So AI is software, but it is also AI. It is also collecting lots of data, yes, but it's also doing something with the data, making inferences about people. We don't know if those inferences are valid. We don't know if they're justified till we can do the kinds of testing that needs to happen, and that we can do it before these systems are put out there. So the infrastructure for testing and evaluation and the way to make sure that these things happen and that systems that do not meet some minimum standards that can impact our rights are not put out there are things we need, and that we are trying to do, or I don't say we, the government is trying to do with the executive order and the guidance. I think we do need legislation, so we're not there yet, but this is something to start with.
Yeah. Thanks. And I have a feeling you're going to bring it back to competition, Cristina, but yeah, what would your response be?
Well, let me start again. And thank you for having me here. I also should say, as somebody who comes from the private sector, sometimes exposed when you're coming from government, it's obvious you are not exposed, but of course, I have been working consistently against Google, adverse Facebook. I've done work for Amazon, Microsoft, Apple, and multiple others. I'm not working on AI matters for anyone, but so I'm not, of course, surprised to hear Andreas essentially talking about ways in which it doesn't work.
Okay. I'm not surprised to hear Andrea, of course, and I'm expecting to talk about ways in which the existing tools we have in Europe are going to be useful in this world. And the analogy with platform is apt. What I don't know you mentioned is that Andreas is not just any member of parliament. He is the father of the DMA, or the main actor so he knows it intimately, and of course has every right to be saying what he does. I think I want to give you a little bit of a broader perspective about what else is happening in Europe more generally, because the discussion and the conversation is by no means going in a unique direction, okay? We heard this morning a very useful discussion between Max and Sarah describing the vertical stack and how effectively there are questions to be considered at the bottom level when you are productizing, but also very much the level of the production of these models. Now, in Europe, we are having different narratives going on at the same time. You're having the UK essentially saying, too early to do anything, we are not going to regulate this. And you can place this into a context perhaps in which the UK has left the rest of Europe. There is geopolitical considerations to be brought to bear, but of course, in a world in which the UK has ambitions to be Singapore-on-Thames, to signal that they want to be free of regulation, not regulate too early, just allow everything to unfold in a way that is more natural, is not surprising. The question then is, do we really do enough with existing tools, or do we need specific regulation? Andreas' answer is we can do a lot with the DMA. If you think of the DMA as platform regulation, effectively AI is a platform which it's being platformized because you're building businesses on top of the infrastructure that AI produces. I would say it's neither or. Is it new law or existing tools? Neither or, because we cannot wait for new law to do anything. Clearly, we need to use the existing law, which is apt. In Europe, there is a big production, which is the AI Act, which is being at this moment is being on the books, being discussed since 2021, and is now coming to the final stages of what is known as the trialogue. But there are, again, big disputes internally about whether it should be extending to foundation models or should be actually be looking at the deployment stage and with what kind of approach. Level of risk is the one thing that seems to be the approach that is being taken. We will see how that ends, but indeed, I agree with Andreas that one cannot wait for the end of the process, and one needs to use the tools that are in place. One that I would certainly want to flag, and before concluding, is really in the US, you have, we discussed it this morning with Alvaro Bedoya, you have the Section 5 of the FTC Act, Unfair Methods of Competition. It is not quite something we have in the same way in European antitrust. We tend to have intervention when there is a violation which is leading to anti-competitive outcome, but not necessarily unfair outcome. So there is some difference there. One feature, one aspect where I think much more attention should be going is really to look into the implication of these tie-ups, these agreements, which are being concluded, which are being adopted across the market. Because this morning, Max again had a slide that described them. It is incredibly important that we investigate and we understand what the implication for competition of these agreements are. This morning, the German regulator concluded that Microsoft's latest investment into OpenAI is not something that should have been notified. So Microsoft didn't violate any rules by not officially notifying it, but it also was careful to say, we do not by this mean to conclude that there is no competition implication. So we have tools. The control of mergers and agreements is potentially very powerful. We should look at the way in which the usual suspects are potentially grandfathering their current market power into AI by virtue also of these agreements. Because essentially, if you do agreements which are exclusive with some of these players, they are no longer competitors. And we have seen this playbook. This is what concerns me. We've seen this playbook play out. We have failed to enforce merger control dramatically 10, 15 years ago, and we are where we are. So to the extent that this is still a platform which is going to be behaving like a platform, we are seeing concentration by acquisition of complements. And we're just kind of saying legal, clever lawyering is allowing us not to is allowing the companies not to really just notify it. And I think substantively that is a major problem.
Okay, I think before I'll come back to Suresh in a second, but while we're on competition, while we're on competition, Andreas, I wanted to come back to you and thank you, Cristina, for saying we have two architects. We have the architect of the DMA and also the architect, one of the architects of the Bill of Rights in this panel. So with that context, Andreas, you kind of listed some of the ways in which the DMA goes makes significant strides, I think, in kneecapping the data advantage of some of the biggest players or gatekeepers, as they're called under the DMA. That said, one of the kind of notable omissions that people have pointed out is the fact that cloud computing providers don't find themselves on this list of designated gatekeepers. So I'm curious, where do you stand? Do you think that the DMA can be leveraged to address the potential choke point in the cloud and compute market, or do you think we should again look to other or new tools?
Amba, I think what has been said is remarkable, and I only would like to add on this. Obviously, these companies that are all stock market listed companies, they want to push themselves also in the age of AI. And generally speaking, this is not forbidden, but it is only not forbidden under the condition of fair competition. And for that reason, I'm arguing so strongly that we should now not make a case that AI is so special that we need special laws for this. No, competition can be fair and reliable in all conditions, be it platforms, being it analog, or being it AI. It's up to competition authorities to make use of all the needs they have to control this, and there is no other law needed. However, as you ask me about the DMA or about this law, it's with all laws. A law is good if the application is very convincing, pragmatic, and useful. And the DMA has just started to be in operation, and therefore we have been seeing the first decisions. We expect now the European Commission to go deeper. And there are still, leaving AI apart, already areas where more action is needed. You mentioned cloud. We have mentioned mapping services. It's a bit a similar issue. If you are looking for a restaurant in a mapping service, you're doing exactly the same compared to looking for that with typing into the words. If you are doing it with your speech, you are doing it exactly in the same way. Therefore, also voice assistants have to be covered. And it's not to make innovation impossible. It's to make sure that competition in these markets remains an issue, which helps also new market entrants to play a role and not to be absorbed or destroyed by the sheer amount of money that there is. That's a bit my argument. Let's not make AI, as we have seen sometimes in Europe, such a specific thing that there is no law to cope with it. No, it's true that we need some basic elements, as OECD is doing, as the United States is doing, as we are also doing at G7 and G20 level. That's all good, but it doesn't change away our view from the fact that competition can be done and enforced with AI as with all other policy area.
Thank you. Yeah, I think that's a good reminder that as we emphasize existing tools, we are also simultaneously emphasizing where they need to be strengthened or go further. Just as a reminder, again, Audrey is at the back, so if you have questions that have come up, you can flag her down. She's around. I'm gonna maybe turn to you, Suresh. Now, I think I can speak for both of us when I say the last year of AI policy has felt a little bit like whiplash, where there's suddenly a blank slate and AI is this new thing, and Suddenly the conversation about AI is always driven by the animating example of chatbots, even though we have a decade of AI systems that are already threaded in commercial and public domains. So you brought up the executive order as a powerful tool. I'm curious how well, or do you think the EO threads that balance between both kind of future uses and current uses, and also the balance between generative AI and other kinds of AI?
That's a good question. I think there's a broader, way in which policy discussions around AI have been distorted by the extreme focus on generative AI. I mean, I was writing down here in my notes. It's not in bold, but it's very big. AI is platform. I'm writing AI is not platforms, and so maybe that's a provocation to bring to the group, right? So to the point with the executive order first, and maybe I'll generalize from there, right? I mean, the executive order is trying to do many things at the same time, and I think various reports on it have described it as a kitchen sink, a grab bag, confusion. Depending on your perspective, I think although you could say all those things about it, but it is definitely trying to address the fact that yes, there are some concerns with the newer systems, the LLMs, the deepfake generators, the image generators, and there's these broader concerns with how they could be used to generate biological weapons, which is but it's something that people apparently are concerned about. And so there are things in there for that. But I think what it's trying to balance that with is, of course, the broader focus on all the things that we've been worried about for many years around the use of AI systems, transparency around them, access to data, how the data is being used, how these systems are being tested, and so on. And so I think what the EO tries to do is sort of, and this may sound a bit corny, but sort of center people in this discussion and understand from that perspective what needs to happen, in addition to one section, which is or a couple of sections very specifically focused on the new technology. So it's trying to balance, in that sense, some immediate tentative concerns, which is why those sections feel a bit more tentative, with a much broader, comprehensive view on what agencies should be doing with the broader systems of AI that are put out there.
Yeah, and I mean, one of the, an emphasis that's very clear in the EO is on kind of independent or testing and evaluation, and arguably that applies to generative AI as it does to all of the other systems. So on that point, because I know in the aftermath of the UK summit, we heard that companies and governments had voluntarily, again, committed to third-party independent testing. And I know there were many of us that kind of had a double take because we were like, oh, that is actually like a fairly strong, outcome, with the big caveat that it's voluntary. But it also kind of like raises the question of, if it is suddenly a palatable option for industry, like why is that? And so I guess my question to you, because I know you've spent a lot of time thinking about evaluation, is how can we ensure that the outcomes of this AI testing and evaluation debate are not susceptible to industry capture?
Well, they are, because the reason why industry is agreeing to testing, especially of generative AI, is because we don't know how to do it.
Okay, I'm going to quote you on this.
And that's why they have agreed to do it, because we have no idea how to test these systems. So why not allow testing? Because whatever we come up with is going to be just fine. I'm sorry, I'm a little bit cynical about this. The places where we do know how to test and have spent years figuring out how to test these things are the systems they don't want to think about, the systems that actually make decisions about people. And so that's where, you think hear companies putting up their hands saying, we will voluntarily submit our loan application algorithms for testing. I haven't heard anyone say that yet. So, and I think that's to my point about AI not being platforms, being platforms, but also not being platforms. Yes, OpenAI, Microsoft, Amazon, Anthropic, platforms for sure. All of these things absolutely important. Consolidation of that. But there's a gazillion other AI companies out there selling tools that are very, very small companies, but with tools that have large of impact. Not that all of these things are not useful. I agree they are. But they are also AI products that need to be tested and evaluated for the actual things they produce. Competition by itself makes sure you have a market where people can compete. It doesn't mean the stuff you compete on is going to be any good if you don't test it.
Yeah.
And so, if we're all competing in a market where all the products are crappy, then great. We have a competition with crappy products. And that's the thing, the other part of the discussion that I don't think competition discussion fully takes into account.
I actually had a sort of question related to that for Cristina, but do you want to come in on this?
Yeah, and just for clarity, when I think I describe it as platform, to pick up the language that Andreas uses, not because one thinks about it in a literal sense, but again, think about the structure here. We're talking about layers of the supply stack. At the bottom, you have productization, and it doesn't mean, so the tool makers, the ones who are implementing, the ones who are doing the plugins, however you want to call them. And that level needs to be certainly also looked into, because competition doesn't ensure that outcomes there are necessarily good. The way in which I think of it as a platform, the place in which I think of a platform is simply where you are building models that are inputs into this lower level. So it is a way in which you are essentially allowing for application to be built on an existing infrastructure. And so that is where we have, in principle, experience of dealing with how do we want to approach the notion that there are companies that are de facto infrastructure and produce an input into a lower level in which is dependent on them. So the one thing I would say, and going back to the capture point, which I completely agree is pervasive here, is that I'm a little worried about, so when I say that neither full new regulation, not necessarily existing rules are sufficient, because the narrative you hear from industry needs to make you sort of wonder what people are, of course, pursuing. Industry tends to say, the usual suspects, this is also novel, we don't need regulation, or you regulators have got tools and use it. Jolly good. We've had tools for decades. And where did we get to? This is the problem. We've had antitrust tools for decades, and we have achieved almost nothing, which is the very reason why in Europe we pivoted to regulation, because antitrust, as it has been pursued, with all great intention, with great goodwill, and this is no judgment on the ability and the intent of the people involved, but it has led to nothing. So I'm concerned that antitrust enforcement, when I think of Europe, what do I need to show to intervene? Well, I need to show that there is dominance, there is a conduct that is anti-competitive. Yeah, mañana, what? In 2029, I will get there to begin to think about some of these cases. It just does not begin to measure. Existing tools, unless you have something to do with unfairness, which in Europe is a very I know you think in Europe everyone is based on fairness. It isn't. We don't even have exploitative abuse as an actual. I mean, we have it in principle, but we don't pursue cases on exploitation. We only do exclusion. So antitrust is normally pursued in Europe is going to be very weak. So Andrea is right. Are we going to use regulation like the DMA to stretch it to this? Possibly. But we're still in the infancy of the DMA. So the whole thing is very unbaked.
Can I just, because
yeah,
I don't, Andreas, I did want to ask you a follow-up, and then I'll come back to you, Suresh. Just on that, I think what Cristina is also highlighting is, and remains true for the DMA too, is that there are certainly going to be enforceability challenges. Those don't disappear with regulation, obviously. So I'm curious from your point of view, what do you see as the kind of key enforcement challenges in the kind of so-called age of AI with the enforcement of the DMA, and if you have thoughts on how those might be overcome?
Well, on that point, I would like to disagree with Cristina and agree. It's true that the DMA in itself is in infancy situation, and therefore still needs to use a lot of deployment and development to really raise the level he can or it can have. But the issue that Cristina is mentioning, saying that AI is so special that we need something special, that's already, from my point of view, a bit the experience of the European Union in relation to platforms. Because also with platforms at the beginning, we said, not we, but some said, this is so difficult, this is so complicated, this is innovation, we cannot do anything, we have to leave this and we have to wait for that to develop and we should not interfere. No, and that's my argument. No, AI is exactly the same what we have already seen. It can be a useful tool for innovation, but it has to be covered with exactly the same competition policy controls as everything else. There is nothing in that sense, if I want to be a bit provocative, there is nothing special with it. There is just data and an algorithm and finished. And this has to be falling under competition policy control as everything else. Is it now true, as Cristina has rightly mentioned, that this is very complicated? Yes. Is it true that we will need more manpower and maybe also a new approach? Yes. But this doesn't change from my point of view. And here I see a bit of danger that we cannot start already today to control with the basic principles of fair competition, also the development in AI.
Okay, I wanted to, Suresh raised a really important provocation before this, which was sort of like competing for what. And so one of the things we've seen in the last five or 10 years now is this idea of toxic competition, right? Where you have all of these large firms that are in a kind of race to the bottom in terms of invasive data practices. And that arguably that incentive is going to be supercharged with AI. So I wanted to talk a little bit about the kind of silos, policy silos that exist between privacy and competition. But to your point, from privacy, competition, civil rights, equity, and just get your thoughts on how and where you see points of intersection or bridging that are possible and what those issues are that help combine the analysis.
That's a big question. So I'm not a competition expert, but I do think about AI a lot, right? So first thing I wanted to say is, I think the issue of, the architecture of the systems, the platforms and the layers, all of this is particularly true in the world of generative AI and is in fact not true for much of the other AI systems out there. Right. And I think that, first of all, it is helpful to distinguish. Having said that, my bet is that within a year, this distinguishing will go away. And this is even more worrying for me personally, because all the infrastructure we have around predictive systems, predictive AI systems, decision-making systems, will be absorbed into these generative AI infrastructures.
Can you explain that a little bit more?
Yeah. So I'm a company that wants to scan resumes and sell that product to an employer, saying, I will scan resumes and build a score saying this person's a great candidate for your job. I use some machine learning, I do some fancy regression, pick your favorite machine learning model, I do some stuff, I sell it to them. Great. Suddenly, November 2022, ChatGPT comes out like, wait a second, I could record a video and I could get their CV in PDF format, I could get all their online media, throw it into ChatGPT and ask ChatGPT to tell me if they're a good candidate for a job and make a little wrapper on top of that. So suddenly my predictive AI system, which I go around telling people is different for various reasons, is easier to evaluate, easier to test than a generative system, has now become a generative system, which makes every problem that we're dealing with 10 times worse because we have no way to test and evaluate generative systems. And that's where the platform issues become important now, because now that system is using essentially a query interface to ChatGPT. Okay, what is ChatGPT doing? Where's the data? How is it running? We don't even know the first answer. So this becomes a much bigger problem. And this is where we are going. We're seeing this with medical data. We're seeing this, I'm beginning to see grumbles of this in fraud detection and other multimodal systems where you can throw multiple data. This is going to become worse. And again, competition rules are going to allow for some transparency in that, but it's going to make the evaluation problem much worse now. Yeah.
But what you're pointing to is not that there is going to be a single problem. I think there are multiple issues that are occurring at different levels. What you're saying is that the technology is going to be embedded and developed into the application, into the products that are going to be commercialized.
Yes.
Right? And so there is a concern about how those will be deployed and what further development of the technology will be performed at that level, and how do we actually police that.
Yes.
And then there is the upper level. The two don't exclude one another. I think one concern that many
Sorry, what is upper here?
I think about, as an economist, I think of vertical structures. Sure. And at the vertical structure is you have the production of foundation models, where the concern is about, as I mentioned before, the grandfathering of power. Because of assets and resources that you need to develop those models into the future. So I think of it as upstream, downstream, but you can think about it in any kind of direction you want. I'm making a distinction about structures. The issues are not exactly the same. Over here, at the level of embedding this technology into the products, there are concerns about what these products will do and how do we police their deployment. But there is a big conversation to be had also about the big, and this conversation is live. I'm not saying anything new. Amba and Sarah and Max have mentioned it. The issue is the grandfathering of the power into the future, because the assets are so special. And so, Andreas, I'm not saying there is anything particularly magical about AI. It's just that it requires resources. If you speak to the people who are involved, the narrative that comes back is, well, look, you need scale. And if you need scale, you need us, suck it up. You don't like it? This is an industry that basically is inevitably a tight oligopoly. Sorry, you don't like it, can't help it. No one else has the money, no one else has the technology. And if you don't like it, China. So I'm saying this kind of narrative is not particularly one that I think works, because it is like saying, well, there is a technological inevitability in the market power. I think that we need to think about that.
I mean, so I'm trying to formulate a proper yes and answer, because I think I agree with everything you're saying, but I want to add something to it. So especially with AI tech, right? There was a time when, this was the size of this room. Mm-hmm. And now this is much more powerful. I am not at all convinced that, well, let me put it another way. I would be willing to bet that within 2 years from now, you could build LLMs with a few machines without needing huge resources, that the scale issue is going to go away, because there's a lot of incentive to make it simpler and simpler and simpler and simpler. We're already seeing, academic level LLM systems, that open source systems that are, below the tens of billions of parameters, maybe at 9.9 or 9.8 billion parameters, and getting lower and lower and lower. So in other words, we are not always going to have locked in scale, locked in platforms. And so we need measures to govern AI systems that don't solely rely on the fact that you have large systems and large platforms that need to be managed for competition. That's all I'm trying to say. I'm not saying that we shouldn't have that, but the technology is going to change. And it's especially going to change if people are saying, oh, if I can make these things smaller and cheaper, I don't have to worry about all the platform level regulation
that
issues.
Would be great. I mean, that means technology beats the problem. Great.
But it doesn't, right? That's the problem. It will not solve any of the problems with AI just to make them smaller and more nimble. It'll solve the competition problems. That's the only one it'll solve.
So wait, I'm gonna intervene here. One, to say that I think your provocation, Suresh, that scale is not inevitable to AI, is one that is probably worth a longer conversation, particularly because I think you're saying that the incentives to scale, maybe like that the incentives run kind of counter to this commitment to scale. But I think we're also seeing that there would be a kind of handful of players that do benefit from this commitment to larger and larger scale AI at the expense of everyone else. And so I still think the kind of jury's out on that question.
But that's why the closed and open source argument is happening. Because the folks who have a commitment to scale and having the advantage of scale are also the same people who are saying we shouldn't have open source systems.
But I don't think that deals with the kind of infrastructure dominance.
Okay. As you said, it's a longer discussion. Yeah.
Totally violating moderator's privilege here. I do want to take the two questions I've got here are quite similar. So I'm going to maybe let this be the kind of closing question to the panel. It's about AI for good, which is obviously this very aspirational narrative. But I think both the questions say, like, what could we do, or what could we see? And maybe I could kind of add to that and say, what are the regulatory levers we have to guide towards more positively transformative AI development, and less to kind of this race to the bottom when it comes to product and uses for AI. Maybe Andreas, we can start with you. So AI for good, and like, what are the regulatory tools we need to get there? Maybe what does it even mean?
No, I would like to come back on the discussion of before, and the question is very helpful. I mean, we are at the moment, also with the executive order, also with AI rules at a G20 level, we are thinking about what specific human rights, democracy related and basic freedoms concerns have to be met with AI systems, so that our basic values are maintained and defended also in AI. This is important. And it will be important without any reference to competition policy. And we may also, on the basis of what has been outlined now, there will be also refinements to this that may be needed. But and that was my point a bit, I think at the moment, even with all the willingness of people that are working in the sector of creating open source, reducing the size, making it available to others, there is a lot of money that is needed at the time being to be invested. And I should not, I'm a Christian Democrat, so I'm not at all against the market, but the market in the investments in these markets is unfortunately bottlenecked by the gatekeepers. They can still raise most of the money. And if you have one or two others that are good enough, there is a risk that they are bought from the market by one of the companies. We have seen it also recently with the companies that are now doing AI for the gatekeepers. They were independent companies largely before. So there is for sure a competition policy, a very basic one at the very beginning. And then we may consider, as it has been outlined, what we can do with the smaller players that may also base their action on AI. And there is also this question in the Zoom stream. How can you regulate such a technology where AI can prompt you with an answer on the question, how do we circumvent AI regulation? How do we circumvent competition policy? For sure, there is an issue. But it has also been happened with platforms, and it has also happened with Ford and Mercedes in the past. They were also trying to do that, and there were also lawyers advising them without any public incentive and impact. So I think we should not put AI completely outside of competition. In the end, if we manage competition for AI from the very first moment, as we should have done 20 years ago also with platforms, then we get already the economic risks controlled. We cannot totally ignore it. We may also be faced with difficult issues, but at least we are attentive now. And if we know that we need more people, we have to send more people. If we know that we have to invest also in digital tools to make a competition assessment, we have to do that. And that doesn't mean that there are not other issues with AI that we can address.
Thanks so much, Andreas. Okay, hot takes on AI for good. Suresh and then Cristina.
Oh, sorry.
I hate the phrase, but I like the concept. So one of my colleagues at Brown works with folks in the astrophysics department, and they sort of use machine learning, AI in general, to help with hypothesis generation for scientific inquiries they're doing. This is becoming a major thing, right? All across the board, in engineering, in science, in medicine, biology, pick your favorite area. In archaeology, people are using machine learning and now generative AI to help with some of the exploratory tasks associated with science discovery. And there's a lot you can do here. You can find patterns. You can find patterns that would be very hard to see otherwise. And it's okay because you're going to take those patterns and you're going to do science on them. But they help you sort of expand the scope of what you can imagine. And sort of the expanding scientific imagination that comes with using AI is very powerful, and I think could lead to a lot. In fact, one of the insight forums on AI on innovation, Senator Schumer's like, how many billions of dollars do you need for investment? I think as a policy tool, investing in actual basic research that can help with this is going to be definitely an AI for good type story. Yeah.
Look, I don't know what AI for good is, and I don't have an answer for that. I think we need to really build a theory of change, which I don't think we have. I hear Suresh saying things like the models are getting smaller, open source is helpful. Allow me, I'm a little skeptical that this in the near term is going to help a great deal. And Andreas is pointing in a hopeful way to this European tool, this digital regulation, which is the only thing that stands between us and bad outcomes, because antitrust is not really delivered. Let's not forget, we continue to say we have these tools and we need to apply them. Well, we have had merger control, we've had all these tools, we've had anti-competitive rules, and we've had 20 years of consolidation that we're now struggling to undo. So, okay, so we are supposed to hope that the DMA, which is a great piece of legislation, but it's incipient, is going to be what stands between us and catastrophe in the latest sort of deployment. I'm again concerned, and so I'll leave it there.
Yeah, I think we can end on that skeptical note, which is also a call to action. Thank you all, and thank you for this really excellent panel. And thank you, Andreas, for joining us. Good time.